Okay, so welcome to topic 6, corporate governance, directors and officers. This is part 2 of our discussion. Now we'll discuss here duties of officers and directors. So the first one, it says in section 112, it is the duty of the director or the directors to act in good faith and in best interest of the company. So if you can recall our discussion on members, I mentioned there that the company directors must act in good faith and always put the best interest of the company as a priority. So whether they are a director of a parent company or a subsidiary, they have to always act for the benefit of the company. Now, if the director of a wholly owned subsidiary company is in a situation where there is an interest which is much beneficial for the parent company than the subsidiary company, the director will have to choose the best interest of the parent or the holding company. Now, in number 3, a director of company that is subsidiary but not wholly owned subsidiary. Now, it says here, when exercising powers or performing duties as a director, were expressly permitted to do so by the constitution of the company, and with the prior agreement of the shareholders, other than its holding company, he should act or she should act in a manner which he or she believes is in the best interest of the company's holding company or another company within the same group, even though it may not be in the best interest of the subsidiary company. With regards to directors of company incorporated under joint venture, again, the director must see the best interest or prioritize the best interest for the joint venture, even though it's not the best interest for the company who incorporated a joint venture. Composition of board of directors and senior management. The company's directors and officers are responsible for managing the company's business affairs. In the small companies, basically, there are times that the shareholders may also be involved in the management of the company. But for larger companies, there are managers who will be specialized in running certain departments. There is no limit to the number of directors that a company may have, but it must have at least one. The role of the director or board of directors is to manage, supervise the management of the business and affairs of the company. Now, of course, in large companies, they will have to assign a separate group to manage the business. Again, for small companies, the directors may also be the one running the business. Now, just a continuation on disqualified director. Under section 129, subsection 4, provides that the person who is disqualified from being a director but who acts as a director is a director for the purposes of provision of the company, which means that director is liable on whatever happens to the company. Now, those professionals performing their work in their professional capacities are not a director. Examples are lawyers, accountants, and receivers. De facto director is also known as a shadow director. They are in fact directing the company or may have an influence on directing the board, but basically they are not appointed as a director. In section 107(1)(c) of the Companies Act 1997, it defines a director to include not only a person appointed to the position of director, but also a person to whom a power or duty of the director or of the board has been directly delegated by the board with the person's consent or acquiescence, who exercises the power or duty with the consent or acquiescence of the board. The definition of shadow director says here, defines a director to include a person not validly appointed as a director, but with whose instruction a director or board of directors may be required to or are accustomed to act. So they are not appointed, but they have influence on how the board works. So that is the definition of the shadow director. A nominee director is a person appointed to represent the interests of a particular group or another person on the board. For example, some companies may have director who is appointed to represent the interests of the employees, a particular group of shareholders, or a director. So, the nominee director need not necessarily approach the company problems with an open mind, and they may pursue their appointer's interests. So, the assumption, the nominee directors will pursue the interest of the one who appointed them. But in the event of conflict, the nominee director may prefer the interest of the company. Company secretary. It is not necessary for a company to have a secretary. If, however, company decides to have such an officer, he or she must be a natural person who is ordinarily resident in PNG. So take note of that. The Companies Act 1997 does not require the secretary to have any special skills or qualification. Where a company has a company secretary, he or she is the administrative head of the company and may be described otherwise as corporate counsel or general counsel or chief administrative officer. The powers and functions of the company secretary may vary greatly from one company to another, but are usually quite extensive. Now, the following are the functions that may be performed by company secretary. So I will not go through all of this. Let's just pick something. It says in the third bullet, organizing company board meetings and general meetings of the company, including preparation of meeting agendas and attending and minuting the minutes or the meeting, and ensuring that correct procedures are followed. Another task is ensuring that the company complies with its constitution and making sure that amendments to it are made in accordance with correct procedures. Another one, ensuring that the company's share register, company records, accounting records, including company's register of charges, are properly maintained. Let's have another example here. Ensuring the safe custody and proper use of company seal. Now, if the company is listed in stock exchange, ensuring that the company meets stock exchange requirements, especially those set out in the listing rules. Despite the fact that he or she is not fiduciary, the company secretary owes the company duties of good faith and loyalty, must avoid the conflict of interest and duty, must not misuse company information, and must exercise reasonable care, skill, and diligence in carrying out his or her duties and responsibilities. So these are something that we are expecting from a company secretary. Of course, we don't want the secretary to put first his or her interests against the company, and also not using corporate information or not misusing those corporate information. And that's it for the discussion on part 2 regarding directors and officers. Thank you.